Yes, sir.
Good evening, a warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Mr. LPE, Rego, Advocate, High Court of Karnataka. Sir, we are fortunate to have you with us today. Welcome to the webinar. It gives me immense pleasure to introduce our today's speaker. Mr. LPE Rego has rich experience as an advocate for 45 years. He has practiced both on civil and criminal matters. A rank holder in LLB examination, he is an alumni of famed Jagadguru Renukacharya College of Law. He was awarded the Diwan Nyayapati N. Madhavrao Prize for the highest marks in the constitutional law. He received this award from His Excellency Mohanlal Sukadia, Governor of Karnataka and Chancellor of Bangalore University. Mr. LP Rego is the son of GM Rego, veteran advocate of years. He was the former assistant state public prosecutor, and he was also a professor of law in Jagadguru Renukacharya College. Mr. Rego is grandson of Mr. P.A. Nazarat, former district and sessions judge. Essentially a trial advocate with extensive legal practice, Mr. Rego has made a mark in the High Court of Karnataka and Supreme Court of India. Both sons of Mr. Rego are advocates and are practicing in Bengaluru city. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, sir.
Thank you very much, Mr. Trivikram. I also take this opportunity right at the very outset to thank the Advocates Association for giving me this rare honor to address a webinar. And I hope that I will be able to do a good job with this. I'm happy to see people like Mr. Joe Joseph on the screen. And I would also, welcome and all the other members who are participating in this webinar. And I will move into it right away. The issue basically now is the concept of advocacy before the courts in Bangalore dealing with testamentary matters, the jurisdiction of these courts in Bangalore. Now, the issue here basically is the Indian Succession Act. This enactment was brought into force on the 30th of September, 1925. To its sway, as many as 12 enactments, which are manifested in various parts of this particular enactment. The enactment has 11 parts. It has 392 sections and 9 schedules. The 9th schedule was repealed, and so we are now left with 8 schedules. Now, before I proceed with the issue, I would like to highlight the method by which I want to address this issue of advocacy. The first is, I will deal with a couple of sections in the initial part of the Indian Succession Act, and then I will go to the history of the enactment for a few minutes, and then I will go step by step on the issue as to how a will has to be drafted, what are the methods by which this is done, the registration of wills, the deposit of wills with the registrar, and various other factors. Finally, I will take you to what is known as proof of wills in common form or proof of will in solemn forms, who a district delegate is, and various other issues which you will gradually begin to perceive. Now, the first 3 parts of the Indian Succession Act deal with domicile, it deals with marriage, and it deals with what is called consanguinity. Consanguinity, lineal and collateral. And in that connection, I will also draw your attention to the schedule under section 28 of the Act, which is at item number 3. And this schedule will explain to you how relationship is to be determined whilst addressing who the relations and the kindred or heirs of a particular deceased person is. Now, to start with, the Indian Succession Act is actually, as I said earlier, a consolidated enactment, and it took into its sweep the Indian Succession Act of 1865, which was promulgated further to the passage of the High Court's Act of 1861. With the passage of that act, several enactments came into play, like the Indian Penal Code, the Indian Evidence Act, the Indian Contract Act. Several other enactments came into force at that time because of power that was vested in the authorities to legislate for the Indians. Now, India at that time was British India and Indian India, and we had other denominations, other countries also here, and these were issues also that had to be reckoned with. Now, as far as wills were concerned, the English enactment of 1837 was the enactment that really mattered, because it took in its entire sweep the various concepts of wills, testamentary succession, and intestate succession. Now, one must remember what really is succession. What do you mean by succession? Succession technically has two concepts. First is transmission of property by operation of law, and the other concept is transmission of property by the will of man. Now, by operation of law is what is technically known now as intestate succession, for which there are several rules that have been formulated, and these rules have been formulated on the basis of religion that various citizens in India have professed. Now, the concept of succession basically was in the earlier days with the Mohammedans, with Islam in India. And as far as the Islamic connotations were concerned, the concept of wills was known to them. They had wills and they had executors. They had methods by which these wills were to be executed, and oral wills were also postulated in Mohammedan law. Now, as far as the Hindus were concerned, this was not there, because they felt that Hinduism was based on a divine ordination, on divine principles, and these issues. And at that point in time, with the two schools of thought, the Mitakshara school and the Dayabhaga school, these concepts were built and were propagated at that time. That is why they said that a Hindu was born with property, but he died without it. Because when he died, he didn't make a will and his property went by survivorship. Finally, the Christians emerged. Now, as far as the Christians were concerned, they go back a long way, because ultimately it is that law that was brought into India by the British and now holds the field in many ways. We have the Hindu Succession Act now, which was brought in 1956, and we also have the Sharia of the which was introduced in 1937 relating to Mohammedans. Now, as far as the issue is concerned, a person was supposed to be, when he died, concerned with three issues. The first was his body. The second was his reputation. And the third was his wealth. Now, as far as his body was concerned, it was a question of his funeral, the method by which his body was disposed of, and issues relating to it, the various religious features and factors that had to be undertaken to ensure that this man ultimately went to heaven or attained nirvana. Now, as far as the other issue was concerned, was his reputation. That was to be protected. That was to be given expression to. And the final issue was his wealth, how it was to be decided. Now, if one were to look into these aspects, you will note that over the years, the concept of a two-third, one-third issue was always there. It is not something that was special to the Mohammedans. It was a factor which was with all of them, even with the Christians. It is two-thirds. When husband and wife are together, one-third goes to the wife. If a Hindu, if a Christian intestate has property which he needs to pass on when he dies, 1/3 of that property will go to him and the remaining 2/3 will go to his descendants. Now, as far as they are concerned, the Christians were concerned about charity beginning at home. That was the main issue. Charity begins at home, and the family was considered the first section of persons who would have the largest, the benefits of this man's wealth, of the deceased wealth. Now, the man would have a personality in his life. That personality would expire when he died. But further to his death, there were certain powers that could be wielded on his behalf, and those powers are what really are the scope of the Indian Succession Act and the other enactments today. Earlier in England, there were these concepts, and at that time there was a break between the church and the kings, and as a result of that, Protestantism came into existence. But by and large, even from the Justinian Code and the French Civil Code, the concept was that charity begins at home. Property must be left to the people at home. It is only the persons who had negotiated with the deceased, who had interacted with the deceased, or had something to do with the deceased and provided him with some goodness in life, was the person that had to be taken care of in his will or at the time of his demise. Now, as far as Muslims were concerned also, this was a concept. They could make a will disposing up to the extent of 1/3 of the property. But the remaining 2/3 had to go by the law of succession, which was already formulated by them and which was part of the law. Now, as far as that 1/3 was concerned, it was not really to go to an heir, because you could cheat the heir, the other heirs, by giving it to only one heir and saying, no, 1/3 goes there. So there's a reduction in what the other heirs would get. So technically that 1/3 would go to an outsider. It will not go to an heir as such, because it would be defeating the 2/3 component that was meant for these heirs. So on the basis of these parameters, the Indian Succession Act came into play. Now, as far as domicile is concerned, the first issue as far as domicile is concerned is with regard to determination whether the courts in India will have jurisdiction in the matter or not. Now, if the deceased owned immovable properties in India, then the issue is that the petition for probate will be one that is in India. Now, as far as his movables are concerned, that domicile will attach wherever he is resident. So if he was based, say, in France or in the US, he would be on that basis, and if he had movable properties there, those movable properties would be dealt with there. But if he had property in India, immovable property in India, then insofar as movable and immovable property, the petition would lie in India. Now, these are the basic concepts as far as domicile is concerned. The domicile of a minor, the domicile of an insane person, the domicile of a wife. How they are to be determined are predicated in the Indian Succession Act in the first part. Now, the definitions there are fairly nominal. Just 5 or 6 definitions are set out there. And these definitions also have been introduced there on basis of time memorial concepts of what a will was. Now, Bentham is supposed to have said that a will entrusts a person with power to make sure that his heirs do not suffer any calamities. And that is why the will is made leaving property to him. It is to ensure that his property goes to them. So these were some of the factors, and even King Henry VIII had certain issues. And then prior to that, we had what are known as the 12 tables that were created in the year 650 BC, where initially on 10 big bronze plaques, the various laws and these concepts were printed. Finally, 2 more were added to it, and these laws that were placed on that held the field for several years to come. Finally, with the Justinian Code in Roman law, the concept of wills and testimonials came into play. Now, how is a will to be made? Now, there are some issues here. Now, for instance, the law of succession is addressed by powers given to the legislature, to parliament, in the concurrent list, item number 5. So laws can be made both at the center or in the state by virtue of on the concurrent list. Now, on the basis of these issues, certain concepts have come into play. Now, whilst drawing a will, the question sometimes is the religion that a man professes. Now, suppose you have a man who doesn't believe in God. He says, I don't believe in God. Now, Article 25 of the Constitution of India says freedom of conscience is permitted. It is protected. It's a fundamental right. Now, if you say, I don't believe in God, then the question is, can he make a will? Or if he makes a will, how is it to be made? And then, if he were to die, what was the basis on which his property would pass in succession? Now, as far as that aspect is concerned, in so far as Islamic law is concerned, in Islamic countries, they felt that this proposition was such and was viewed very gravely, and it even postulated a death sentence for the man if he had given up his religion. Christians had other concepts also on this, but the Hindus did not have anything insofar as this aspect was concerned. Now, as far as the frame of and the infrastructure provided in the Indian Succession Act, the point here is, if a man, anybody can make a will. Section 59 clearly says who can make a will. He should be a person of sound mind, not a minor, and in a position to dispose of what he wants under his will. Now, this particular concept, testamentary succession, if a man who is a non-believer makes a will, that will could be given expression to. It could be given effect to. But interstate succession will not attach with that man. So how do we address this issue? As far as the Indian Succession Act is concerned, this is an area, a gray area and a dark spot. We are not able to deal with this issue because here is a non-believer, and how his property goes in interstate succession cannot be addressed. But the Muslims finally said that what could happen is, if he recanted, if he came back, then he could be given back his property, and his wife, who was at that time also imprisoned, and she was also forced to undergo loss of status and other issues. And then finally she had to come back with a limited and smaller dower. That is one issue insofar as the law, the lacuna in the law, insofar as as an atheist is concerned. Now, leaving that aside, we come now to domicile. Domicile I've already dealt with. Then we go now to the issue of marriage. Now, marriage does not give anybody any special right. There was a proposition in the earlier days which said that if you made an agreement before the marriage with your wife saying that she's not entitled to any property in your estate after the marriage, then that agreement could be upheld. But that particular proposition, that provision has been removed from the Succession Act, so it doesn't stand as on date. Now, as far as the wife is concerned, the question here is, marriage doesn't give her any right in the property of the deceased. It all goes according to the law of succession. And now, who are the consanguine relations, distant kindred, have to be dealt with. Now, the section here tells you how it is to be done. You have what is called linear or lineal consanguinity or collateral consanguinity. Now, in lineal consanguinity, the relationship is in a direct line. You go up to your father, you go up to your common ancestor, your father, your grandfather, your great-grandfather, up in that line. As far as the descending relations are concerned, you go to your son, your grandson, your great-grandson, and it goes down that way. But with a collateral, consanguinity goes in this way. You go back to a common ancestor. You go up to that common ancestor, and when you reach that common ancestor, you move downwards. So you're related to your brother, not in the first degree. You're related to your brother in the second degree, because you'll go up to the common ancestor, who is your father, and then come down to the man to be reckoned with, that's your brother. The man after your brother's son is your nephew or your niece, if it's a daughter. So they are your collaterals, because you are not directly related to him in a straight line. You need to go in a roundabout way, and these are the persons who will ultimately be your heirs and come into reckoning at the time the interstate succession comes into play. Now thereafter, in the enactment, after we have dealt with these three issues, the rules that govern Christians and Parsis come into play. They're fairly elaborate, but fairly simple also. I will not elaborate on that, because that will take a lot of time and will not enable me finish what I need to tell you about the rest of this act. Now, as far as the Succession Act is concerned, in its operation today, there are various other enactments that are in force and which come into play. The first is the Registration Act, because people might want to register their will. Then you have the Evidence Act, if there's some litigation. The Code of Civil Procedure, if you have to go to court. Now there are various other enactments like the Court Fees Act and other issues like this relating to the manner in which you need to take this forward. Now the first and the most important thing here is who can make a will. Section 59 deals with this. Now if you go to the very next section, it clearly says a father of whatever age can make a will for appointment of a testamentary guardian to his minor son or his minor child. Now, a father of any age, now this is a camouflage. A father of any age can also mean a minor. The courts have held that yes, a minor could be involved in such a situation, because at that time, we had the Indian Christian Marriage Act of 1872, where under that act, marriages of minors were allowed. A minor could get married to another minor, and if he got his consent of his father in terms of section 19 of the act, he could marry. Now there were two concepts there. One was marriage in a religious format, that's in a church, and the other was in a registry. Both these concepts there, and they still exist in the statute book, speak of minors. So therefore, the very next section has created a bit of a stir, because they say a father of any age. It doesn't say a minor in open words. So there also, there's a bit of a lacuna. And today, of course, there are issues with the Indian Majority Act and other issues. But then, if you look at it this way, that the Indian Succession Act is a special enactment dealing with succession and intestacy and other issues like that, then this enactment may stand to prevail over the general statute. So a minor, in certain circumstances, can make a will. Now the question is, how does he make that will? That there is an area of darkness in the Succession Act. So if we need to work on that particular issue, then we have to go by the various other factors that are built in the Indian Succession Act. Now section 61 clearly says this: a will or a part of a will, the making of which is caused by fraud, undue influence, coercion, or such other importunity that takes away the free agency of the testator, is void. Now, we have to see how this will is made. Now, there are various types of wills. They are broadly put into two sections, privileged and unprivileged wills. Privileged wills are made by airmen, soldiers who are or people on a dangerous expedition. Now suppose you were sending an astronaut into space. He's on a dangerous expedition. Or you have a soldier all set to go into battle. An airman ready to scramble, hearing the siren to go into battle. He may not come back. But at that point in time, he is enabled to make a sort of an oral will to his senior officer, explaining what he wants done with his estate if he were not to come back. Now, such a will can remain in force for 30 days, as long as the fear of war and this fear survives. And the method in which it is to be revoked is also indicated in the enactment. Now, as far as unprivileged wills are concerned, they are dealt with by section 63 of the enactment. It tells you how it is to be done. The man must have what is called testamentary capacity. He must be of a sound and disposing state of mind. He must know what he wants to do with his wealth. And you, as the advocate there, called upon to draft his will, must address this issue in a very, very shrewd way. Because in the past, in England, there have been great personalities involved in conveyancing and drawing of wills. But ultimately, these persons, their own wills, which they drafted on their own, fell foul of the law, were infirm in many ways, and led to a lot of litigation. Now, today in India, we have document writers. Document writers are issued these licenses, or deed writers as they are called, when they pass an examination which only deals with conveyancing in a roundabout way, and also Stamp Duty and Registration Act. But the basic laws, the concepts of laws and the other issues which lawyers are required to undertake and deal with are not within the knowledge of these persons. Now, many times, a person is looking at the cost involved. Instead of going and engaging a lawyer who is knowledgeable and in a position to do this, he prefers to go to a deed writer. That deed writer will create all sorts of situations there, and he will prepare a document which is wholly infirm and will ultimately lead to an litigation which will ravish the estate of the deceased. He will have nothing left. Years ago, I believe in a big battle in England, two barristers were heatedly arguing the issue. Finally, the judge asked one of the barristers, "Would you please tell me to whom these properties belong?" At that point in time, one of the barristers stood up and told the court, "My lord, these properties here belong to my friend on the other side and me. And when we are finished with them, whatever is left will ultimately be distributed to these people." So the danger of litigation arising by a will not being drawn properly is a very, very pertinent factor to be taken care of. Now, as far as these issues are concerned, when a man is consulting with a potential client, he needs to know that client. He first has to assess him for his testamentary capacity. He has to then check and see what his properties are, what his family is composed of, and take into consideration all these factors and then formulate that will. After that will is done and he has clearly ascertained from the client as to what really are his intentions, which must be carried out after his demise, he then draws this will. Now, no special wording or form is needed for this will, except the attestation that might be called for in terms of section 63C, which says the will must be attested by two witnesses in the presence of the testator, who at his request, in his presence and in the presence of each other, have hereunto attested this will as attesting witnesses. Under the impression that the testator was executing his last will and testament, and that was in his mind. So they needed to get an impression like that. Now, under section 3 of the Transfer of Property Act, attestation is defined. Attestation is not defined in the Succession Act, but in the Transfer of Property Act, section 3 does not require you to know what the content of the document is or all these other factors that are required in the Succession Act. So that concept of attestation in the Transfer of Property Act cannot be imported here because it's a very superficial attestation that is contemplated under the Transfer of Property Act. But in this enactment, it is fairly large and fairly in depth. The attesting witness must know what exactly they are doing in such a situation. Now, sometimes we have witnesses who play up. They don't come forward to depose at that time. They raise all sorts of difficulties, and 101 problems arise because of that. Sometimes witnesses also say, you pay me. If you want me to attest the will and if you want me to depose in court, then you make me also a benefit in the will. Give me something, only then I will support you. Now, these are factors that one must take care of. We have to ensure that the estate of the deceased is not put to this kind of harassment. This is one aspect of it. Now, as we go further, the wording of wills, then the interpretation of wills, and certain other factors are there. Now, in this particular concept, there are three doctrines that come into play. The first is the doctrine of ejusdem generis. When you're drafting the will, it must be so clear and unambiguous. You must have it certain as to whom you are passing on the benefit to, the legacy, and the identity of that legacy and factors that attach with it. That is one aspect. Then you have what is called the doctrine of persona designata. Now you may say, I leave to my wife this house, but actually your wife may have misled you. She may have been married to somebody else and her marriage to you is no marriage. Okay. She may have had a daughter through her first husband. And she may have represented to you that I have divorced him, or he is dead, or he is not to be found. Now, here you have said my wife, but she is not your wife, because in law, she was not entitled to marry you. So the question there is persona designata, you're talking of your wife, but she is not your wife. Now, if you name her there and explain it in thing, it may be another issue. But the court in England held that no, persona designata, since it was a falsehood, since it was an illegality, insofar as status is concerned, she was not entitled to any benefit. But the daughter who was given a benefit directly was given this. Then the third doctrine that comes into play is the doctrine of acceleration. That is where you gift a person a particular property and then something happens in between, and as a result of which that property becomes available to you earlier than contemplated. So at that point in time, the benefit given there is accelerated. It comes in faster. So then you are entitled to take that bequest, which is legal and can be upheld in law. Then we have what is called the rule against accumulation. You cannot make a will leaving property to a person beyond 21 years. Minors, now you may leave it to a child for more than 21 years. You cannot leave this property for more than 21 years. That accumulation must lapse. It becomes void after 21 years. So minority also, during that period, this accumulation is not permitted. So this is the other main issue over there. Then you have what is called redemption. Redemption is a situation where you leave a property in your will. Today you own this property and you say, I'm giving it to X. Now at the end of the day, for some reason at all, 3 years later or 5 years later, you sell that property. It's not yours now, or the property gets destroyed and you're not able to deal with it. It gets acquired or something like this. In such a situation, though it is in the will, it is not there. It is physically or factually not there. And in such a situation, that bequest fails. It is called redemption. That is, the legacy gets redeemed. So this is another factor whilst dealing with wills, with the interpretation of wills and the various issues. Now, in wills, we have a very important personality there. an executor. This executor in the old days was a man. The deceased always wanted a man of substance, a man of knowledge, a man of greatness. Now, advocates are the only persons who are known as learned. We carry that tag with us wherever we go, the learned advocate, the learned counsel. No other profession has that kind of a tag. Whether we are learned or not is a different issue, but we carry it. So we are duty bound to live up to it, to live up to being learned men. You don't say my learned plumber or my learned contractor. You don't even say the learned judge, though we extend this grace to them out of sheer respect and on account of due process of law. We say technically the sober judge, the wise judge, the good judge. These are the descriptions of a judge technically. But today it goes now because they were formerly lawyers and they were learned and issues like that. So we go by these concepts of learned. Now, the executor basically is a person who can be anybody other than a minor. Now, as a minor, he cannot be appointed as an executor. But a minor can hold property. And if he makes a will or wants to make a will, then he can make that will only through a guardian. A guardian appointed to look after him, that will be made through him, an executor appointed also through that guardian. Now, people went for lawyers because lawyers were the leaders in the old days. Every second great man in the world today, in those days, were lawyers. And executors were known to have knowledge. Literacy was poor in India. We didn't have people who knew what the laws were and how to go about all this. Half the time, all this was done in the villages. And we had revenue lands. And there the Hindu law came into play because in Hindu law, you went by these family trees and issues there. You had a Muktarnama, power of attorney, adoption deed. And this is how property was transferred in the rural areas, in agricultural areas. Now, the courts have clearly held that these kind of successions to property cannot be given expression to because the tahsildars and these revenue officials don't have that power to adjudicate on succession. So that particular area now has been closed up. Now we have executors who have to be appointed, and then the method by which they are appointed and how they go about their work is also a factor to be taken into consideration. Now, all that is provided for in the Act. Now, an executor may be appointed, but he need not take that executorship. He can renounce it. He may say, no, I'm not interested in doing this. Why should I do it? Why should I break my head running around with all this over here? I'm not. He can renounce his executorship. In such a case, then he has to execute a document renouncing it, or if he doesn't renounce it, then somebody else who has an interest in the estate of the deceased can go and make an application to the court. Then, before anything is taken into consideration with regard to representation, the court issues a citation to the executor. He is called, please come here and tell us whether you're going to do this or not. Then if he renounces his executorship, the matter ends. So this is how executors are dealt with. Now further to that, in the Succession Act itself, there are certain situations where limited grants are given. Sometimes when the will is lost or only a draft is available, there are circumstances in which limited grants can be given by a court to people who come before the court with these kind of difficulties. So that is a further aspect of this. Now, the High Court has concurrent jurisdiction with the district judge. Normally, it is the district judge in terms of section 264 who deals with the grant of a succession certificate or a grant of a probate or letters of administration or just letters of administration with will annexed. Now, what happens is this power is given to the courts under section 300 of the Indian Succession Act. Now, the High Court has also got power to appoint what is called a district delegate. That is done in terms of section 265 of the Indian Succession Act. A delegate is a person appointed by the judge, a knowledgeable person, invariably a judicial officer, who is authorized to deal with applications for grant of probate or even letters of administration or letters of administration with the elects, which is of an uncontested nature. So he could be given these powers, and also in rural areas and places where there's no district judge, certain powers by special notification under section 299 can be given to munsifs and other judges, civil judges in rural areas to exercise these powers. So that is another factor. Now there's a special power also placed in the hands of the High Court. The High Court can deal with removal of executors under section 301. If an executor does not do his job properly, or is guilty of devastation or of misappropriation or any other sort of infirmity in the manner in which he has functioned, he can be removed by the High Court on a petition made to it. Now, this is another feature. Now, the essential issue that one must understand is with regard to representation to the estate of the deceased. A man can die making a will, appointing an executor. In such a case, probate is granted, and probate is granted only to the executor appointed under the will. The second situation is where he makes a will, but he does not appoint an executor. So when he has not done that, then your petition will be one for letters of administration with will annexed. The copy of the will is annexed so that the court knows what is to be done, and that will is to be executed in context of that will after the grant of letters of administration. The third issue is when a man dies without a will, when he dies intestate. That's when a grant of representation is made as grant of letters of administration. There's no will annexed there. The grant is made. Now these provisions are dealt with by section 276, 278 of the Indian Succession Act. Now one must remember what is the powers of the district judge. When the district judge deals with these issues, he exercises power under section 283, and one must remember that one can also file a caveat under section 284 of the Indian Succession Act. Anybody having an interest in the estate of the deceased can go before the court and lodge a caveat. The caveat is very simple. It is there in Schedule 2, which says, let nothing be done in the estate of, in the matter of the estate of X without notice to the caveator. So a caveator can lodge this, pay the requisite process fee for issue of summons to him or notice to him if a petition is filed. Now this particular concept also has far-reaching issues. Now, when you formulate your petition, you're required to formulate your petition on the grounds or on the basis of what is stated in the provisions in section 72, 272, 276, 278. You have to technically plead whatever is there. And if you have pleaded properly, there is one other requirement. If it's a petition for probate, then you have to supply also the verifying affidavit or the verification of at least one attesting witness to the will. Now, that is the factor. Now, if such a will is formulated, I mean a petition for probate or letters of administration or letters of administration with will annex is formulated in that fashion, then it is open to the court in the absence of any contest to allow that petition straight away. Section 270, without evidence, it clearly says if you have formulated that petition in accordance with that provision and there is no caveat entered or there is no objection, you can allow that petition straight away. High Court of Karnataka was doing this in the old days. I have appeared in many matters in the High Court where this issue was the minute, no objection, the judge dictates the grant straight away. Now, after the grant is made, one must remember, in the grant, the court postulates a 6 months period within which you have to file an inventory. Now, what happens is when you go to the court and file a petition, sometimes very often, the banks will say, okay, You get a probate income, you get succession income, they kick you out. So you're not in a position to get all these details very effectively because they keep saying, who are you? Tell me who you are. We cannot give you, these are confidential information. How can I give you details of his deposits and all that? So court gives you that opportunity now. Now, when you file your petition, you have to file what is called an affidavit of valuation. That affidavit of valuation is what is predicated and drawn in the Karnataka Court Fees and Suits Valuation Act. It has two parts. The first part deals with the assets. The second part deals with the liabilities. So on the basis of this affidavit of valuation, you draw out tentatively what is the value of the estate you will be dealing with it as an administrator or as an executor. So that is required. Now what happens, the first thing that the court does is when you file the petition and it's admitted, it orders notice to the Deputy Commissioner of Bangalore. It then orders what is called a spot citation. Then it also orders Gazette publication or publication in the newspaper. Now, Gazette publication is a lengthy process. It takes 6 months, 8 months, sometimes 1 year or 2 years because you don't have space in the Gazette. So many people apply to the court and ask for waiver of the Gazette publication, allow us to publish it in a local newspaper circulating in Bangalore or wherever the deceased was. So that is done. Then the court takes out a spot citation which goes to where the court bailiff goes to the spot where this man was living and he places on his outer wall a citation saying that so-and-so has applied for a grant of representation and if you have any objection, please come to the court. The hearing is on this day. So that can be done when this is done. Now, a notice is also sent to the Deputy Commissioner having jurisdiction in that area to ascertain the value of the property. Now, in those days, the value of the property was of great importance. Now, in those days, in the earlier days, we had what was called the Estate Duty Act. Just after independence in 1954, the Estate Duty Act came into play. We had to pay estate duty. Then you had to pay probate duty. Probate duty in Karnataka was exempt 1,000 rupees, 5% on the next 3 lakhs, and then 10% on the balance. So on an estate of 20 lakhs in those days, you paid as much as 1,85,000 as probate duty, and then with all your paper publications and other issues, it would cost you another lakh of rupees. This was a burning issue with people who had to apply for probate and letters of administration. They did not want this. So there was a hue and cry, and ultimately they sought to amend the law. They amended the law by saying it is not necessary to go and apply and get a will probated. Now that may not be a proper legal position that has been set up. Anyway, we'll come to that in a short while. Now, in the meantime, what happens is, as far as the court fee is concerned, the DC would value your property and then predicate what it is, and unless you produce the estate duty clearance certificate, the grant would not be given to you. And the grant is not given to you till you in those days paid the probate duty. Today, the grant is allowed, and unfortunately, the probate duty comes in at that stage. Sometimes the grant remains there without the probate duty being paid, and 2 years, 3 years go by. And nobody attends to the issue of the inventory and the accounts. Now, the accounts have to be filed for within 1 year. And one must remember that once you file a will in the court and probate is granted in respect of that will or letters of administration with that will annexed, that becomes property of the court. It is a permanent record of the court. It will remain with the court and will never be returned to you because there's a grant. And tomorrow, if you apply for it, the court must know in respect of which will this grant was made. So that will remain there. You cannot take that will back. There are provisions also in the code, in the civil rules of practice, where these are documents which come in file 1 and item A and permanent records, and they cannot be taken back. Now, the issue here is if you don't comply with the filing of an inventory within the 6 months that has been given to you, it is possible for you to explain to the court, I could not get all this information, so extend that time. But if you don't do that, then you become liable for prosecution. Because the court has entrusted you with a job, you have undertaken to file the inventory and other issues. If you don't do that, then the question arises, prosecution for non-compliance with section 370. You are liable to be prosecuted in terms of section 176 of the IPC. Then you are required to file the accounts within 1 year. And if you don't file the accounts within 1 year, section 193 comes into play and you are liable for prosecution even there. So one has to be very careful. And the courts are also charged with retention of the entire records of those proceedings in that court itself, which granted you that representation. You can't take it elsewhere. It cannot go to the record room. It remains there till the final accounts have been filed and the file closed. Only when the file is closed, it goes back to the court, to the record room. So these are issues there. Now, coming back here, the issue of estate duty has been withdrawn now. When Mrs. Gandhi passed away after that in 84 or 85, the Estate Duty Act was scrapped. So no estate duty is payable. So there is a loss to the state exchequer on that particular basis. Now they have said no probate is necessary. So no probate duty is payable. So to that extent, the state is suffering a loss of funds. Of course, as far as probate duty is concerned, it is now confined to 39,000 because the rates have been reduced. 1,000 exempt, on the next 3 lakhs, it is 3%. That 3% is 9,000. 3% works out to 9,000. And the balance, it is capped at 30,000. So totally you paid 39,000. And there used to be a surcharge, which was another 900 rupees. That has been removed. So now you pay 39,000 on your grant. And then the probate is typed on that, is printed on that and given to you. And one must remember that if it's a probate, the will has to appear in that grant. Similarly, with the letters of administration with the will annex, it has to appear there. Because you have to explain to the court how you have dealt with the estate. And remember that also, when you pass on these assets, the asset of the executor is necessary under section 332. Even if the executor is a beneficiary, he may be the son of the deceased and is a beneficiary. And as executor, he has to transfer to himself in terms of 334 of the Succession Act. If it's not done, then there are difficulties. So even that has to be taken care of. The duties of an executor first is with regard to the funeral of the deceased. That is why I go back to body, reputation, wealth. On body, to ensure that he gets a dignified burial, that he is put, that the various ceremonies and things are done, and he is given a proper farewell. That the executor has to do. He is entitled to even advance money for it and ensure that the man is buried properly. Now, the executor also has certain powers that flow from the office. And the moment that probate is granted, the property vests in the executor from the date of death of the deceased. Similarly, the administrator. Now, they have certain powers. Now, the probate, the executor is placed on a higher footing. He can do many things which an administrator may not be able to do. Administrator, of course, the executor may be subject to the directions in the will, and he may be able to proceed only on the basis of what is stated in the will. So he is, guided from beyond the grave in that way. Now, as far as the administrator is concerned, he cannot lease property for more than 5 years. He cannot sell. He needs court permission. All that is dealt with section 307 of the Indian Succession Act. Now, these are issues there. Then finally, it is open to the court to refuse to grant letters of administration to a Hindu or a Muslim if he has applied for it. That discretion rests in the court. There's a statutory provision, if I remember rightly, it is section 298. Court can reject that. It doesn't need to be done that. So that's another factor. Now we go back to contest. Now here is a caveat that is filed. Caveat is filed, and now before that, the executor, the courts are required to function on what is called the rules governing probate and succession matters. Many people are under the impression that these rules don't exist. Now for the lower court, there's one set of rules, and for the high court, there's another set of rules. I've xeroxed them and I've kept them here. Anybody wanting a copy can feel free to just message me and ask me. I will be very happy to send you copies of this. I've had them done entirely. Now, the rules tell you also how you have to go about this. When you go about this, it tells you how you file your petition, what happens, what the court has to do, how it addresses it. Everything is beautifully set out here. There is no ambiguity. Now, if there is contest to the will, if the will is challenged, now what happens is your caveat is filed, petition is filed, caveat is put up along with the petition. Now, the caveat is then considered, there is a hearing. In that hearing, if it is established that the caveator has a caveatable interest in the estate of the deceased, then he is entitled to contest that will. Then what happens at that point, the proceedings become what is called contentious in terms of section 295 of the Indian Succession Act. And what happens is immediately the suit is ordered to be registered as a testamentary original suit. Not an original suit by itself, a testamentary original suit, TOS. Then in that suit, the petitioner for grant of probate becomes the plaintiff. The caveator becomes the defendant. The plaintiff is only required to, at the initial stage, dispel, establish sound and disposing state of mind and dispel suspicious circumstances surrounding the execution of the will, and then the burden lies on the caveator, the opponent, the defendant, the man impugning the will to deal with this issue. So a suit is convened, issues are framed, evidence is let in, and finally a decree is passed. That decree is also passed in terms of the rules. The rules tell you exactly what is the decree to be passed. The format of the decree is set out in the rules, in that testamentary original suit. And if it's a matter that was tried by the district judge, or as today in Bangalore, the city civil judge, an appeal lies to the High Court. Now, if you have invoked the concurrent jurisdiction of the High Court, then an original appeal lies from there to the High Court within 30 days. But remember that, within 30 days, from the district judge to the High Court in 90 days. But in the High Court to the High Court is only 30 days. That's a limitation. So these are the factors that one needs to understand and to follow while dealing with cases in the testamentary jurisdiction of the courts. Now, as far as this testamentary suit is concerned, it can go into several years, and finally, probate duty will also be ordered to be paid. But any money that was paid in terms of the court fee, which is predicated under the Court Fees Act, will be given a rebate. After the grant, the filing of the inventory and the final accounts is the next factor that has to be taken into consideration. Now, there has been a judgment that has been passed recently, maybe about 10 years ago, in terms of section 118 of the Indian Succession Act. Now, 118 was a provision which said that no man who had a nephew, niece or near relation could make a will, leaving property to charity, unless he made that will within 12 months of his death, and within 6 months deposited that will in a person or an official created in law to take deposit of this particular will. The idea was that charity begins at home. Charity should not be taken advantage of. And what would happen, you see, in this particular judgment, which was rendered by a full bunch of the High Court, paragraph 22, if I remember rightly, the judge said that the opponents here have not come forward to really explain why with Christians this was the issue. You take out the judgment. Now, as far as that judgment is concerned, is no man having a nephew, niece or near relation. So the degree of relationship was within third degree. Now, what would happen in the old days in England, from where this particular provision came in terms of the Mortmain Act, there in England, there were feudal lords. there were these big manors where these feudal lords lived. And what would happen is when he was dying, the priest would be called in. The religious officials would be called in. Now, as far as Christians were concerned, there are what are known as 7 sacraments. Just like with Hindus and just like with the Mohammedans, they have at particular ages in life, certain formalities go where you are, thread ceremony or a circumcision. Similarly, with Christians, at the 3rd stage, you have what is called penance. Penance basically means you confess to a priest and explain to him the bad deeds that you have done, and finally you are pardoned for it. Okay, then you come back and you lead a life. Now, what used to happen in those days was when a very rich lord was dying in his manor, these fellows were called in, these priests were called in to administer the final rites, because even there they have what is called an extreme unction. Now they call it anointing the sick. So in those days, these people would come and everybody would be sent out of the room, because he would be, the deceased, before he passed away, would be explaining his, his life and things like this. But what would happen was he would be put in fear of death, hell. He would be told, man, you have done the most grievous things in life. You will never get heaven. Down there, you will go to hell. So fearing that, what can I do? Please tell me, how can I go to heaven? They would say, leave everything to the church. So all this, a will would be kept ready. All this property would be passed on to the church. It became a big issue. And many people overnight thrown on the footpath, because church was merciless. They went in there and just threw these guys out. They landed up on the streets. It became a grave situation. And therefore, they came up with the Mortmain Act. The Mortmain Act made these provisions. So they said no deathbed issues 1 year before you die. And if you leave anything for charity, when you have people close to you, then these things have to be formulated. Apparently, in my humble consideration and opinion, this particular concept and proposition was not really placed before the Supreme Court at that time. Of course, it didn't really make much of a difference today, because not many people are leaving to charity, not many people have money to leave. And that's a particular field now, because poverty is rampant in India, and this particular area is dying out. So anyway, that particular issue was quashed, and they declared unconstitutional. That was one issue. The other issue, which came up in 1920 itself with the judgment of our own High Court here, Mysore High Court, was with regard to a nominee, either a survivor in a bank account or a nominee. A nominee is not a person who is a legatee under the estate of a deceased personality. That particular proposition was upheld by Justice E.S. Venkatramayan, a judgment reported in 1984 Supreme Court in the case of Sarbati versus somebody else. In that particular case, he said a nomination only indicates a hand that must collect or receive the benefit, but you hold it in trust for the estate, and you have to divide that money that you receive in accordance with a will if there is a will, or interstate succession accordingly there. So that is another judgment which expressed that particular position. But today many banks, nominee could be. So they just pass on this money there, and many people suffer because of this. And we as advocates must know this and ensure that banks don't play this. Because nomination, somebody may just come forward and say, I'm the nominee, and just vanish with that property or with that money. So this is another factor. So as far as the issues are concerned, these two judgments are also of importance. And then the most important judgment is the one rendered by the Supreme Court in 1954 by Justice S.R. Das, where he said that the probate court is only concerned with the validity of the will, nothing else. A man may have left his property to anybody else, done anything with it, but as long as that will has been done in accordance with law, if it is the product of a sound and disposing state of mind, then the court doesn't need to go further. He may say, Rashtrapati Bhavan belongs to me, I'm giving it to X. Whatever it is, he may have had his reasons for it. And that also brings me to what is called a fake will. Sometimes people create fake wills just to show that they have properties, and then they want to defraud banks or defraud other people or try to take away property in various ways. So that is what is called a fake will also. Now this would be a will if you are leaving property to somebody else, not an heir. It is called an inofficious will, because you're not going by your heirs, you're giving it to somebody else. So this is another factor that one has to take into consideration. I think I'm running out of time, Mr. Tariq. Can I go on? Hello?
How many more minutes, sir?
It could go to quite a length of time. Maybe another 10 minutes or 15 minutes? 10 minutes?
10 minutes, could you please wind up? Yes,
Okay.
sir, please.
All right. Now, as far as these issues are concerned, in India, we had in the Registration Act a provision for deposit of wills. Now, these deposit of wills technically stemmed from Section 118. The provisions still remain in the Registration Act, but they are not, in view of 118 being struck down, that particular provision there doesn't come into reckoning at this stage. Now, a will can be registered after a man is dead. You can take the will, go to the registrar, produce the death certificate, and the registrar has authority to hold an inquiry, decide whether that will has been executed properly or not. The attesting witnesses will be called, they will be examined, and finally the registrar, sub-registrar passes an order saying this will is to be registered. So that will is registered in the sub-registry, and then the original is handed back. So that is also a factor that is available in the office of the sub-registrar. This is another factor. Now, I explained to you also with regard to what is called revocation of a grant. Now that is dealt with by Section 263 of the Indian Succession Act. For just cause. Now if a probate has been granted, it can be revoked. If you can show by just cause that this particular will was not processed in the particular way it should have been done. And there are about 5 conditions in which the revocation can be done. It is like an ex parte, not an ex parte proceeding. It is it's a summary proceeding, and a petition can be filed with a nominal court fee of just 20 or 25 rupees. And if you can establish that these 5 conditions or any one of them was present, the grant can be revoked. Then you go back to the court and the matter is established afresh. So I will stop there now because the rest of it is very lengthy. It'll take me another couple of hours or so. So since I'm under term-bound constraint.
Thank you, sir, for a stupendous presentation. Now, with your permission, can we move on to the Q&A session?
Yes, yes, I'm ready for anything.
All right. I see Mr. Vijay Kumar raising his hand. Yes, Akash, request you to unmute Mr. Vijay Kumar. You're unmuted. Please go ahead.
Sir, my question is, while drafting will or execution of the will, testator can appoint a beneficiary of a will as an executor or a legatee.
He can appoint. He can bequeath to the executor. He can appoint. He can bequeath to anybody there. But if these 2 people, the executor and the beneficiary, sign the will as attesting witness, then ultimately in the inquiry the will be upheld. But the benefit to the executor as his appointment as executor and any benefit legacy given to him will lapse. The deceased will be deemed to have died intestate. Similarly, if a wife attests the will and the husband is the executor, in such a situation also her attestation will be upheld, but the benefit will go. It gets revoked. Marriage revokes the will.
But what is the term we have to mention while executing the will as a executor party is concerned?
No, he will be the petitioner in the case. No, you will say petitioner is Mr. X. He is the son of so and so. He is a reputed person in the society, and he has been appointed as the executor under the will of so and so, who died on such and such a date. And this person is the same person as Mr. X mentioned in that will. That's what you have to specify in your petition. Those are the language is required for that. Yeah, Mr. Sadhana?
Thank you, sir.
Your question. Yeah.
Thank you,
Yes,
sir.
Yes, sir.
You could unmute Mr. Gupta, and subsequent to that, we'll take up few offline questions, Akash.
Okay. Hello, Mr. Rego.
Hello, sir. How are you?
How are you? Fine, wonderful. Sir, now.
You have a long time.
Yes, good, sir. You remember me?
Yes, yes, very much. So who can't forget you?
Okay. Now, the wills are deposited with the advocates also.
Yeah.
Now, after the death of a person, the beneficiary under the will comes. Then what is the role, what is the duty of an advocate with regard to the wills presented with him?
See, sir, he is only a custodian.
Custodian.
Okay. Now, holding the will of a deceased person is not an official act that he is undertaking. He is not a notary who holds what is called a mystic will. See, a notary public can, in his register, can be given a will in a sealed cover, and he keeps it. That will is called a mystic will. Now, an advocate in the normal course is, because of the trust the public have in them or his client has with them, that will is left with him. Now, what happens is the moment you come to know that so-and-so has passed away, there's a burden cast on you to write to the people concerned and saying so-and-so died in such and such a day. He has left this will with me. I propose to open it in the presence of the heirs, and kindly let me know what is to be done. So let them come and then decide that. I mean, you don't need to take the task of holding that will and tomorrow being accused of other things. Because sometimes these people find it very easy to blame you for all sorts of things. Avare madkottidare namge, avare madidru, namge idu bitbitru. You know this, no, sir?
I know.
I've seen a lot of it in the courts over the years.
Yes. Sometimes advocates will become the witnesses.
Not only witness, sometimes they become the accused also, sir. Most often they accuse the case.
Okay. Thank you, Mr. Rego.
Thank you, sir. Nice to hear you.
Thank you.
Thank you, sir. We have one offline question. Whether e-will should be prohibited, that is the electronic will.
Electronic will, what do you mean?
So, the question is very, it doesn't clarify what it is exactly, whether e-will should be prohibited. I assume it to be electronic.
First and foremost, you see,
a will drafted in an electronic mode. That is what the person tries to convey.
No, the point here is, sir, you see, the fundamental concept of a will is that it must be made by a person when he's of sound and disposing state of mind. Now, if you say a will is passed on electronically, now what is the evidence that this will has been executed when the man was of sound and disposing state of mind? One. Two, we are not sure whether the testator has really caused the issue of that letter, of that will to this personality. Then how is the attestation to be done? People may be at different places. They have to be together. They have to receive an acknowledgement. This is my last will. A blind and dumb person can make a will. Now, how do you organize this? You see, and there is no provision in the Succession Act to enable the execution of wills in email format. So, in my opinion, it will not be possible because the infrastructure that has what infrastructure for it is not indicated in that query. Let them come out with it more explicitly, saying this is how it is to be done. This is how the will. You are just saying electronic mode. So then, are you postulating a sort of a webinar when all the witnesses and all sit together like this, and then we do a draft and I read out the will to somebody, and my clerks are here, your witnesses are there. If something is to be done on those lines, then maybe an email will could be upheld. But here the gentleman says it should be prohibited. So there is already no provision for it, whether to enable it or to prohibit it. So where is the need for that? It's a redundant question.
All right, sir. Thank you, sir. One more question offline. Please clarify about inofficious will.
Inofficious will is a simple thing, sir. It only means that the property is given to third persons. It's not given to the heirs. Third persons get it. Outsiders.
So the family.
Yeah, not the family. That's all it means.
All right. Can we take up question by Mr. Nagendra Prasad and then by Mr. Harish? Akash, quickly request you to unmute Mr. Nagendra Prasad. He has raised his hand.
Hello, sir.
Good evening, sir.
Hello, Rego, sir.
Yeah. Hi, sir.
Sir, nice presentation, sir.
Thank you very much, sir.
Sir, one question.
Yes, sir.
One of the will executed in the year 1978, and the testator has no issues, only wife, no children.
Yeah.
And now the wife has sold the property, and one of the relative has filed a suit.
Okay.
That property is been bequeathed to him. So is it a valid suit, sir?
No,
coming to the will, there's only one attested with witness.
Then there's
And
no
that
will
will-
at all, sir. There is
What is
no
that?
will at all.
There's no will at all.
There's no will at all. That will lapse, and he should apply. Will not file a suit. He should have applied for revocation of the grant. It would have cost him only 20 rupees to do that, and the matter would have ended there with that revocation.
Yes. But it has not been
The
done.
will drawn in accordance with law, sir. The will requires two witnesses.
But it's only one is there in that.
Ade, one ididra illa adu will.
Oh, will is gone.
Illa.
Okay.
It's not a will
Okay.
at all.
It's not a will at all. Thank you.
All right. Quickly, if you could unmute Mr. Harish. Yes, we'll take up his question.
Good evening, sir.
Good evening, sir. How are you, sir?
Yeah, fine, sir.
Yes. Sir.
Okay, you just now mentioned that bequest in favor of the executor. If executor is a witness, that bequest will lapse.
Not only the bequest, sir, the appointment will also lapse.
The appointment will also lapse.
That's
According if the bequester, if the executor is given life interest in the property of the testator, then what is the
Whatever it is, sir, it's an bequest. Whether it's a
life interest? Life interest.
Whatever it is, it's a bequest. The section is very clear, sir. Section 67. Shall I read it out to you?
Because the ultimate beneficiary will be somebody else. So this
That
person
doesn't
only gets
matter.
life interest to
He is
stay. If
taking
it
a
is a wife,
benefit there. And then, if he is the executor, even that appointment fails. Appointment as executor fails. 67 is very clear, sir. I'll read it out to you if you don't mind.
yes, sir.
Well,
Yes, sir.
effect of gift to attesting witness. A will shall not be deemed to be insufficiently attested by reason of any benefit thereby given either by way of bequest or by way of appointment to any person attesting it, or his or her wife or husband. But the bequest or appointment shall be void so far as concerns the person so attesting or the wife or husband of such person or any person claiming under either of them. A legatee and a will does not lose his legacy by attesting a codicil will confirms it. So it's very clear. Appointment. He is appointed executor. Even if he's given a life interest, there's a bequest. Something is given to him. Life interest in the Duddu Barudu, Badge Barudu. He gets all that benefit, no, sir?
No. Life interest to only live in the property. I'm saying.
Yeah,
The final beneficiary
he's getting
is
monetary
the
worth there, no? He's getting value there, but it's a bequest. He's given something, some benefit.
benefit is to only reside. That's in that case. I'm saying.
But that benefit is not, it lapses, sir. Under the law, appointment and his appointment is executed to start with lapses because he has signed as the attesting witness.
So I can understand
Yeah, that's why when
appointment can lapse, sir, but will the life interest not continue? That's my question.
That will lapse also, sir.
Because practically seeing lot of wills, practically if you see lot of places, but that is still continued and people are not aware of this particular life interest being lapsed. That is why.
No, that the statute is very clear on that. No benefit, whatever it is. However small or however big, here he's been given a life interest. He may live to be 70 years or 50 years after that. And during that period, the value of that property is enjoying it is without paying rent and all that. Then he may sublet it, he may do something.
More so in the case of wife getting the life interest. In most of the places in the wills, if you see, it is the wife who is given the life interest.
That
and
is where we come in, sir. We have to be very careful when we draft these wills, sir. That is what I'm trying to tell you and tell all of you all there today. This is the mistake. And most of these fellows, many parties believe in being very thrifty. They go to all these document writers.
Yeah, that's
where the trouble starts.
In most of the will registered, they go to a typist in front of the sub-registrar office, get it done and registered. In most of the places, you get to see this clause where wife is the executor, the children are the ultimate beneficiary, wife gets life interest in the property. That's most of the.
May be so, but if she signs as a witness, then she is that bequest goes. That is the difficulty. These people don't know it, sir, and that is why we are having trouble in the courts with this.
That's the most of the wills have this problem, sir.
See, there are rules also for going about this. Follow it, and you're on the best wicket.
Thank you, sir.
Right, sir. Thank you, sir. One last question we'll be taking up. Sir, good evening. If the executor is abroad and has become citizen of foreign country, can he execute or does he have to right to do since he has another country citizenship? It's very ambiguous, but it is with regard to the citizenship.
See, sir, section 61, I think, of the Trust Act does not allow a person who's resident abroad to be a trustee. There's a statutory bar under the Trust Act. So technically, if he is living abroad, then he is not in a position to come forward here and act as the executor. Okay. So if there is difficulty in giving effect to that will, anybody interested in the estate of that deceased can apply. If he is showing no interest in coming back, and after all, under section 222 and 223, he has to renounce, or he has to indicate to the court that I am prepared to do this. If he is not doing that and sitting somewhere, what happens to the legatees here? What happens to the estate of the deceased? There is another factor I forgot to tell you all because of the shortage of time. There is a provision in the Act which deals with protection of the property of the deceased. It is from section 192 to section 210 of the Succession Act. And there, within 6 months of the date of death of a person, a petition can be filed for protection of the property. A curator can be appointed in such a situation, and that curator is given powers to go there, take over the property, manage it. There are several factors there, and that doesn't prevent you from filing a suit. Protection of the estate will is mandated in terms of section 192 to 209 or 210. So here, a man sitting abroad cannot keep the estate to, devastation, because anything can happen in such a situation. He is bound. There are certain, after all, it is a confidence reposed in him by the testator. And you sit in the foreign country, you give up your nationality and do nothing here. What happens to the heirs?
All right, sir. Thank you so much. I think we will have to end the session now. On behalf of Advocates Association Bengaluru, I extend my heartfelt thanks to you, sir. Thank you so much for a very educative presentation. Thank you so much.
Thank you. Thank you very much. And thank you, gentlemen and ladies, who have participated in this. I'm grateful to you all. Thank you.
Thank you, sir.
Thank you.
With your permission, we'll be logging off the session now. Thank you.
Certainly, sir. Thank you.